We're going to get on the road here. This is the House Judiciary Committee. It is the 2nd of April, 2025. Just 5 fun-filled days to go. We have a number of items on our voting list, and we're going to start at the top at Senate Bill 81. Senate Bill 81 is there is a motion to concur. Is this a motion to concur in House Bill 445? Okay, so House Bill 445 was the cross file, so we are concurring in the Senate amendments, which makes it the same as Senate Bill 81. Did we vote Senate Bill 81 yet? All right, well then let's start this from the beginning. Okay, so we're doing 2 things. We're gonna vote Senate Bill 81, and then we are, then there'll be a motion to concur with the Senate amendments to House Bill 445. So why don't we start with Senate Bill 81, which...
Senate Bill 81 to 445, or are we conforming 445 to Senate Bill 81?
We're conforming 445 to Senate Bill 81.
Thank you.
More precisely, we are voting to concur in the Senate's amendments to 445, to the House bill. That was fun. So, okay, we're on Senate Bill 81, which does not have amendments. And there was a motion for a favorable, I heard. Is there a second? And a second. All right. So we're on the bill with a favorable. Does anybody have any questions as to Senate Bill 81?
81 does not have amendments. From us.
Claire, am I right? Claire is saying there are no amendments to Senate Bill 81. From us.
From us, yes.
From us. The Senate changed it. Right. Right. Okay. So the Senate changed it, and so that's where we are. Are there any further questions on Senate Bill 81? And no, we have not voted everything. Stop. Seeing none, the Vice Chair.
Yes.
Yes. Valentine.
Yes.
Yes. Crutchfield.
Yes.
Yes. Cardin. It's not here yet. Tomlinson. Yes. Embry. Yes. Yes. Pasteur. Oh, I didn't hear you. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Stinnett. Yes. Congolo. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Sample Hughes. Moon.
Yes.
Yes. Conaway. Yes. Kaufman. Yes. Williams.
Yes.
All right, so motion for favorable is adopted. So now we have received back House Bill 445, and the motion is to concur in the Senate's amendments.
Second.
So motion to concur in a second. Any further discussion on the motion to concur? All in favor of the motion to concur, please raise your hands. Is there anyone opposed? It's adopted unanimously, and we will concur in the Senate's amendments to House Bill 445. Thank you very much. We're now on Senate Bill 207, which has a number of changes from the way that it was.
I mean, House Bill 445, can we add?
No, because it's a motion to concur
Okay.
with the Senate amendments. We're not adding any more amendments, because if we were adding amendments, we wouldn't be able to, yeah, okay. All right, so Senate Bill 207, Senate Bill 207 is where we are now. The bill, this is Holly, right? They made a couple changes in the Senate. They also eliminated language at the back, on the back page of the bill, which would have required failure to remain at the scene of an accident to be a automatic, or failure to remain at the scene of an accident that results in the death or bodily injury of another person to require the use of the interlock. And so that's the biggest change, I think, between what we passed. Oh, we didn't pass it, between what was introduced and what we have before us today. So let's do this. Could I have a motion on the bill? Motion for favorable and a second. Now discussion on the bill, Delegate Erican.
Thank you, Mr. Chair. So they added the interlock, and that's regardless of whether the person has had a history with alcohol issues.
They
or-
subtracted it. That was
took it out.
precisely the issue, that however tragic as this sounds, it's possible that you have a situation where someone fails to remain at the scene of an accident that results in death or bodily injury, any bodily injury. It may or may not have involved alcohol.
Right, they're just.
So adding
yeah.
that to the list of things for the interlock was a question.
Okay,
Yeah.
so we took that out.
So it's out.
Okay,
Yes.
all right, thank you.
Are there any other questions? All right, this is a straight favorable on 207. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Carden? Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Okay. Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? It's, okay. Is that a yes?
Yes.
Yes. All right. That's Senate Bill 207. Senate Bill 391, I don't think was cross-filed. It's a motion for the favorable. Is there a second?
Yes, second.
Okay. It's moved and seconded for a favorable. All right. Any questions regarding the bill? So I think it's changing, they have to provide, it's the IID report. They have to, it's asking the Police Training and Standards Commission to annually review the report published by the Independent Investigations Division of the Office of the Attorney General. So it's making them review a report.
Okay, thank you.
All right. So are there further questions about Senate Bill 391? All right, seeing none, the Vice Chair? Yes. Valentine? Yes. Crutchfield? Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right. Senate Bill 391 has adopted a favorable. All right. Senate Bill 360. Yep. This was your subcommittee or David's subcommittee? David's subcommittee. Delegate Moon and his subcommittee dealt with the issues related to revenge porn. This is Senator Hester's bill. There are amendments, 733229. Does somebody want to speak to what the amendments do? Either you
Sure.
want to do that? Delegate Moon.
Just conceptually, where we went with this is to retain the Senate's, on the civil side, to retain the Senate's goal of clarifying that you could bring a suit for defamation per se for fake pornography. And on the criminal side, we used the existing revenge porn crime, but widened the definition of the subject matter material to include both the real and artificial images so as not to split the definitions into two. We just put it all into one.
Favorable on the amendment.
There's a motion on the amendment, is there a second? Okay, motion. And then a second on the amendment, we're on the amendment. Are there further questions to Delegate Moon for the subcommittee's work on the amendment?
Just gratitude.
Just gratitude. I thought I saw a light flash, but I was wrong. All right. All in favor of the subcommittee's amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 21. Anybody opposed? All right, the subcommittee amendment's adopted. On the bill as amended, there's a motion for a favorable and a second. All right. Any questions on the bill? Delegate Schmidt.
Thank you, Chair. I do have a question. How does this align with House Bill 663? Do we adopt those amendments, or do we incorporate that into this bill? I'm pulling it up now.
In the bill. That's, we ended up rewording, because we ended up with a collapsed definition of the subject material, just one definition, we reworded basically the concept of what's being attempted here into the bill. So yes, I would say what this bill is trying to achieve is included in what's done here, yes.
So it incorporates all the items, computer generated, the actual visual, all the deepfakes?
Well, all right,
things?
I'd have to go to the exact wording of it. Claire, would you say that your wording covers all of the case scenarios contemplated in Lopez's bill?
Yeah, we reworded the language just to really streamline it and make it more concise, and it captures all of the concepts that were intended in that bill and some other bills on the same topic.
Okay.
So it incorporates like all the different forms?
No, not all of them. Like Warman had a bill that was about regulation of the hosts and platforms.
Yeah, James has one that's child.
Yeah, so all this deals with is civil defamation suits and the criminal offense.
So we're gonna do more foreign later.
Bills.
Vice Chair?
Respect to regulating the provider, that is in federal law currently, right? Okay.
Further comments about the bill as amended? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin? Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
All right. Favorable motion is adopted. And now Paris Hilton. Senate Bill 400. It's a motion for a favorable and a second. The subcommittee looked at Senate Bill 400. Did we need to amend 497 at all? Were there amendments? Yes. There are amendments. I was going to say, I thought there were for both. All right, so we're starting on Senate Bill 400. So Senate Bill 400 has amendments 863223. The motion for the amendment, is there a second? All right, that's a very good question. Then we should ask Lauren to come up here and help us. So let's do that. Which subcommittee? This was family, right? Would you like to?
Family.
Oh, correct. So we'll go to Delegate Crutchfield instead because Lauren just ran away. Delegate Crutchfield.
Okay, so the amendments, what they do is, there's several different things going on here. So one is to clarify how this actual legislation is applied to transport companies. And so what it states is that it's only used for transporting children to the final destination, which is a residential child care program. The other thing it does is it expands the damages for the individuals. So it now adds in compensatory damages. It specifies that this is prospective. This legislation is prospective in nature. Also that there's going to be a 10-year statute of limitations on it, on bringing in action. And also that it provides that parents cannot waive a child's right to bring a civil action. The other thing this does is it makes sure that it is clarified that mechanical devices or restraints cannot be used, such as handcuffs, those kinds of things. And it also takes out the DHS, which also usually transports children to other kinds of camps and other kinds of things. They are removed from this legislation entirely because in this legislation, there is a time period that transports can only transport children from the homes to wherever they're going to. So DHS is eliminated from that. I think I got everything? Okay.
Delegate Schmitz, then Erican.
Thank you, Chair. I do have a question. The compensatory damages, are they against the abductors, or are they against the parents, or are they against, how does that play out?
Well, usually they probably are going to be against the transport company,
Transport company?
but we will see.
And that will be outlined in the amendments? That's outlined in the amendments?
Yes.
It
that
is, okay.
That allows for the compensatory damages.
All right,
Yep.
thank you.
Delegate Erican.
Thank you, Mr. Chair. So, okay, so we made it so that it can still happen, but we put guardrails around how it can be done, essentially, is what, and then how did we decide on the 10-year statute of limitation? I'm just,
So the way the bill sponsor explained it was there was some concern with the fact that children cannot bring a claim until they're obviously
Right.
18 years or older.
Right.
And in many cases, people don't discover that they have these actions until much later in time.
yeah,
Also, they may still be under the care of their parents, even though they may be 21 or 22 years old. So this gives them an opportunity to now think it through, figure it out, and file the claim.
okay, so does the 10 years starts from when the event occurs, or when they turn 18 and they're eligible?
Well, it should when they're 18, because that's when they are able to actually bring
Okay,
a claim.
so till they're 28, they'll have an ability to
That is
seek?
correct.
Okay, all right, that's good, thanks.
Sure.
I'm sorry, Delegate Valentine.
Thank you, Mr. Chair. I may not have the most up-to-date version, but I believe where it says here, it says, and I remember the 10-year in subcommittee, but it says 10 years after the date of the alleged violation in the version that I have.
Well, I would assume, depending, again, now, if they're older children or whatever, but to file a complaint, you have to be 18 or at the age of, but let me
Brought
double check.
shall
You
be
wanna
filed
check
within
that?
10 years.
So let's let Lauren double check the final, yeah.
Because I thought his intent was to make it from the age of maturity.
Typically, you get on becoming an adult, which they're required to file before the victim. Okay, so they have to 21, and then they're going to get the 10 years, typically.
So they will get 10 years after the age of
Yeah,
21.
I think that's what.
I just want to make sure it's worded right.
I thought it was 8. Yeah.
Lauren, would you like a second to?
Yeah, I need the numbers.
So we're going to come back, let's come back to this. Let's come back to this, let's make sure we're right. So we'll come back to both 400 and 497 here in a moment, just because that's the relevant question. It's come up a couple times. Let's make sure we get it close to something being right. Senate Bill 421, this is a cross-file of Hutchinson.
Bill, FHB
All right. And it is there, it's being offered without any amendments. There's a motion for a favorable and a second. Any further discussion on Senate Bill 421? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes, gotcha. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Dinette? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right, Senate Bill 421, the favorable motion is adopted. All right, we're going to move ahead to Senate Bill 621. 621 next. 621, and then we're going to take up House Bill 1378. 621 and then 1378. 621 is heavily amended coming out of the Senate. It had a portion that would have required a very large fiscal note. They've stripped that out. What remains is basically a study that they are going to be doing, and it gives the judiciary the ability to request information effectively from law enforcement and from security officials to be able to identify the challenges they have with safety at their facilities across the state. I believe I'm stating that correctly, maybe for the first time this week. Holly, is that right?
Those agencies just have to report to the Chief Justice.
They have to report to the Chief Justice. We asked the Chief Justice, I asked the Chief Justice whether he really needed us to make that happen, and the answer was yes, they needed us to make that happen, so we're going to make that happen and go from there. So there are no further amendments that I see to Senate Bill 621. Is there just, can I have a motion? Motion and a second?
Okay.
Yes.
Okay.
Are you okay?
Yes. Did we skip Senate Bill 4?
Yes, we did.
Thank you. That's what.
Yes, we're on 621, 621 now. Any further questions about 621? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield? Yes. Cardin? Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Dinette? Yes. Congolo? Yes. Erican? No? Oh, yes, yes. Just checking. Just checking. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right, thank you. Senate Bill 621. Now, House Bill 1378, Chairman Wilson's bill. There are significant amendments that we discussed yesterday to the bill, and I believe that they're under, and I'm looking to Lauren. I'm sorry, just making sure the most recent, I think, set of amendments and the ones we discussed, 853229.
Yes, 853229.
853229. So again, the amendments, can I have a motion on the amendments? Motion for the amendment and a second. So the bill as it was brought in would simply stop further claims being brought under the Child Victims Act. This would change that and would say that after June the 1st, the maximum a person could claim would be $700,000 against a private institution, $400,000 against a public institution. It also seeks to address the issue of claim or claims in that it would say that the claims would be all all encompassed within a $700,000 or $400,000 settlement. It states that 25%, the fees that council may charge would be 20% if a settlement was made, 25% if it was a judgment, so they went to trial. It asks the Supreme Court of Maryland to adopt rules to implement the provisions of the act, and it requires annually the judiciary to report information regarding settlements and regarding the awards that are made under the Child Victims Act. We are on the amendment. Is there discussion on the amendment? We'll start with Schmidt and then go to Eric.
Thank you, Chair. Can we get copies of those amendments? It seems rather lengthy, and I was not here for the hearing, and I do have some questions regarding the public versus the private. And then you mentioned that June 1st, is that 2025?
2025. The effective date of the bill would be June 1st, 2025.
Okay. Can we get copies of those somehow?
You should have, yeah, they were sent.
Last night, is it 8 o'clock last night, the latest version?
I think so.
Here, it's here.
All right, I can pull it up.
Delegate Arakan, then Congolo.
Thank you, Mr. Chair. So for the restriction on attorney's fees, we're only restricting attorney's fees for those cases against public employees, not against private?
As I read it, I believe it seeks to encompass both. It seeks to encompass both the public and the private.
What page is that
because it
on?
deals with that on page. It's the next to last page into the final page of the bill as amended. Under 12109, council may not charge or receive fees that exceed 20% of a settlement made under the subtitle
25% of
or 25% of a judgment made under the subtitle.
Okay.
I'm going to let you continue to, I'll go to Delegate Congolo and they'll come back to you.
Okay, I missed the committee hearing, so I apologize because
Sorry.
this is kind of new to me. So did you say that the claimant, or you mentioned that the 700,000, does that encompasses all claims, or is that an individual?
All occurrences. So the idea would be as if there were bad things that happened on multiple different occasions with the same, effectively the same defendant.
Okay.
They would be treated as one claim.
I got you, okay, so if
The
they
argument,
had
the argument being that this was not
incidents-
about the money, this was about discovery and bringing information to light and make it clear how these things have happened over time.
Okay, so if they had experienced 7 instances
That's
in
correct.
a setting, then they would be lumped into one, and they would file a claim based on...
Altogether.
Okay, altogether.
And it's my understanding that, and again, this is an agreement between the parties that they're presently in negotiation. My understanding is that they are, at this point, they've agreed to that, to treating all as one large claim for each individual person as it stands.
So they basically decreased it from 1.5 million to 700,000?
To 700,000 for private, yes.
Okay.
The argument that was put forward by Chair Wilson is that in the case of in the public occurrences, the public government has provided other services, either in the healthcare realm, that would justify the difference between the two.
And what's the rate for public?
I'm sorry?
Is there a different rate for public? You said the 700,000 applies to private.
Under the existing law, there's a different rate, there's a different cap depending on whether it's a public institution or a private institution. The private cap right now is 1.5. The public cap right now is 890,000.
890,000?
890,000.
Okay.
So the idea is that after June 1st, the cap would be lowered to 400,000 for public cases and 700,000, which is proportionate to the drop. And the 400,000 number is equivalent to the number that you would get as a cap under the Local Tort Claims Act.
Okay. All right, thank you.
Delegate Grammer, then Sample Hughes.
Thank you, Mr. Chair. So I'd be inclined to vote for the amendment because I think it does have some positive changes to the bill. I wanted to ask that the last time we considered a bill this size was the asbestos bill to me, when we were starting to think about broadly how claims were impacting the state. Do we actually have any data about the claims thus far, which are kind of moving us forward on this? Because there seems to be an urgency that I don't think the numbers have really sussed
My
out.
understanding is that there are 4,500 claims that I got that, my understanding, again, from the Attorney General's office. I think the idea here and the reason for the bill is to begin to try to get an idea of how many cases we really are dealing with, to give people the opportunity between now and June 1st, if they want to come in at the higher caps, they can do that. We don't want to completely close the door, however, and so we'll leave the door open for people after that time. If there are further claims that come to light, they can come to light under those caps, but that's what we're looking at right now. That's also one of the reasons we ask in Section 3 in the uncodified language of the bill for the Supreme Court of Maryland to adopt rules to implement the provisions of the act somewhat consistent. I don't think that the General Assembly asked them to create rules for the asbestos cases, but the idea is it's basically a little, hey, it's sort of waving a flag saying, hey, you should probably think about how you want to handle these cases going forward so that they can handle them in a judicially expeditious way.
So the other question I have is regarding, I think the worst part of the amendment is that it combines what may be multiple infractions into one claim. Is there anywhere else in civil liability where we kind of just merge that into one claim? Because frankly, that's the worst part of these cases, is that these children could have suffered this over a course of years. These could have been dozens or hundreds of infractions.
My understanding is that there are. I don't do work in civil, though, and I'm trying to make sure that I also, don't go too far out of bounds here. But by and large, my understanding that is not wholly unusual. It's a question of, I think in this area of the law, it is something that apparently the parties have negotiated as they've begun that process. So I can go based on that. Delegate Sample Hughes and then Phillips.
Sure. Thank you, Mr. Chair. So just as you were indicating that the 400,000 matches up with local tort claims, does the 700,000 have a similar
The idea
connection?
is it takes it from 890 to 4. It takes it from 1.5 to 7, and it's a roughly the same proportion from 1.5 to 700 than it is from 890 down to 4.
Okay, so that's the rationale or how it comes to that number.
Yes.
Yeah, I've been grappling with this one because I heard the witnesses loud and clear when most of them were saying that the money is not anything to them. They want the therapy, they want the accountability. But I guess that the frustrating thing is that, I don't believe we could ever put a price tag on any of that, because the mental health of someone, you can't put a price tag on it. But it's just, I guess it's still on the surface a little disturbing from the public versus the private for me. And so that was kind of where I was grappling with. But I appreciate your information on the 700 versus the 400.
Thank you for that. I mean, I will say that was one thing that came up in the hearing and then the discussions surrounding the hearing, that the distinction that's there, and one of the thoughts was that if the cap was lowered to 400,000 on the public side, but not lowered at all on the private side, that would also be seen to be unfair. And so the idea here is, again, to bring them somewhat proportionately down to the same rate. Yes, Delegate Sample Hughes, then I'll come around.
In this process, and I know we talked about that there's going to be systems that are going to be set up, mediation and things of that nature. Does it also include therapy at all, or any level of?
I mean, that's going to be decided in the individual cases as to what's appropriate for that individual person.
Okay.
And we're not going to get to that level we're not getting to that level of specificity with this.
Right, but when we had the persons come and testify before us, I asked one of the lawyers to just say, what does this look like on a timeline? And we talked
Right.
about mediation, we talked about this and that, which was not specifically a financial component. It was just things that were going to happen within this process. So that was where I wanted to know about the
No,
therapy.
and I appreciate that. I think there are going to be negotiations that are going to be ongoing. They're going to continue. And so those services and everything will be part of that negotiation.
Okay.
I would say, again, another reason for asking the Supreme Court to establish rules in this area is to have them have the Rules Committee of the Judiciary begin to look at this and say, okay, what do we need to do? What structures do we need to put in place? One of the biggest questions was about ADR, as you pointed out.
Right.
And we do not take up ADR in this precisely because I think it needs to be better defined and needs to have more work done in that area. And that is something that the Rules Committee can do. That's something that they certainly can look at going forward, as these cases are still relatively new. All right? Delegate Phillips, then I'm coming around the mountain. Delegate Phillips.
Thank you, Mr. Chair. I want to make sure I'm reading this correct. And while we're leaving this open, we are putting a deadline of December the 31st, correct? As I read this?
So the effective date of the bill is June 1st. So that's the hard line. It's that where the caps would change is on June 1st of 2025.
And then the subsequent claims would need to be filed before the end of the year? Are we putting a cap on the time frame?
Not stopping it at the end of, that should have been.
Then maybe I'm misreading, or maybe that was yesterday's.
That was the original bill, I think, where it said that.
So we pulled that out of this amendment?
That comes out
the most recent
altogether.
amendment?
Yeah.
Okay, thank you. And
There
then,
is not a hard stop. There's
Okay.
not a hard stop on people being able to bring claims that were barred under previous rulings. That's the universe of people we're talking about. So let's also be clear about something else. This isn't every claim altogether, even ones that arise from something that happened tomorrow. This universe of people are the people whose claims were barred because of the statute of limitations and the alleged statute of repose that occurred in previous years. So this is that universe of people, not everyone who could potentially bring a claim going forward. Okay?
all right. I am concerned about, we still leave a pretty substantial opening for people in the future. And I do recall the discussion that many times people don't come forward until they're ready. And so I get that, but I am concerned that we're still leaving ourselves pretty exposed on that. And the concept, the civil concept on multiple claims in a multiple occurrence is the concept of joinder. And so the civil courts do allow us to join claims.
Like the opioid side.
Like the, yes.
Coming around, Delegate Tolles, then Pasteur, then Tomlinson, then Cardin.
Thank you, Mr. Chair. Just a brief comment. And I wasn't going to really comment too much about this bill. I did have a conversation yesterday with the bill sponsor. Just because I wanted to ask him his thoughts out of respect, you know, for the victims and the pain that they go through. But I talked to him, and I understand and support why he brought this bill. I heard over the radio, and I was really concerned with some of the trial lawyers seem to be coercing or you know, asking individuals, if you experience this from the state, give us a call. It almost felt kind of ambulance chaser type of thing. So I just wanted to make that comment, and I told the chair I would say it because I understand, you know, that while it's not something he necessarily wanted to do, it's, you know, hearing those commercials, I was really taken aback. I don't know if anyone else heard them, but it seemed really ambulance chaser to me, and he kind of agreed with that. So I did tell him, he said it's okay to mention it. He did say he support what I said. So I just wanted to make that quick comment. Thank you.
Delegate Pasteur.
Okay, thank you, Mr. Chair. Excuse me, can we go back to the universe of people? Explain, when you said who had been previously barred, can you just explain that, clarify that for me, please?
So there is a universe of people whose claims, whose claims for basically child sex abuse were barred, and they were barred over time, and they were barred mostly, these are claims that have arisen, it's kind of hard to set a first date, but 60s, 70s, 80s, 90s, 2000s. And they were not able to bring their claim to the courts because they were barred for a statute of limitations.
Got it.
Or what was called a statute of repose that the Supreme Court of Maryland basically just threw out a couple months ago. So there is that universe of people who saw injuries that happened during that time. That's the universe of people that we're talking about.
Okay.
People who have been, if they were allegedly abused today, they would be able to bring claims consistent with existing civil law. And I think that we lifted the statute of limitations on those claims. So going forward, this isn't an issue. And going forward from a couple years ago, it's not an issue. This is dealing just with that universe of people from the past who have those claims.
So, thank you. So, when you spoke earlier about the differences between the amount for the private and the public, and that does bother me. And you said that it was felt that there were some services. What are those services that are going to make that come together, match?
They may have received services under Medicaid. They may have received other mental health services. Again, it would have to look at individual cases to see what services they may or may not have received. But the rationale, we're basically continuing the rationale that was in the original Child Victims Act. We're continuing the rationale for the distinction between private and public, but we're also, in this case, since we're lowering the cap on the one side, we're proportionately lowering the cap on the other as well.
So if you're looking at the services that were rendered to these folks, then will there be consideration based on what people got or didn't get in terms of the amount? I'm just trying to figure out how you put
I think you'd have to
one set amount on people's pain.
Well, I think a lot of this would be services that were already provided as opposed to services that would be prospectively provided after a settlement or a judgment. So the settlement or judgment would.
I'm not talking about the settlement. As you're looking at it and you're processing at 400, whatever it is.
I understand.
Are you looking at the
I understand, but my belief is that the settlement or whatever they would receive and that would cap at 400,000 would be reflecting future services as opposed to services that they received in the past.
Okay.
That's the way I would perceive it. And that is certainly, I think, the way that their attorneys would perceive it. So.
Thank you.
At least I believe so.
Okay.
Delegate Tomlinson.
I know you've touched on this, answering a ton of other questions, but can you just make it clear with the statute of limitations, what it currently is and what is or is not changing as it relates?
It's unlimited presently.
It is, yeah.
If something happens today, there is not a statute of limitations today. In the past, if you want me to go back and go through the history of what the statutes of limitations were, I don't mean to make light of it, but it was the subject of repeated legislation and a lot, they moved.
It was 20 years, for example, before 2025. They had 20 years after the date of the, which is the expiry. That was the last one before it became any time.
And that was extended from a previous, I think from previous, it was like 10 years at one point. So again, what it did is it left a group of people unable to bring claims that they effectively, that came to light after the 20-year period had expired. And so that's why we're looking at that universe of people in the past.
Okay.
Okay?
All right, thanks.
All right, Delegate Cardin.
Thank you very much, Mr. Chair, and thank you for explaining that. And I think that what that means is that over time, this group of people is going to dramatically reduce over time as these things fan out, which is, I think, part of the reason why if we solve this problem once, it shouldn't rear its head again. That was the going forward issue, so thank you. I just wanted to say publicly thank you, because I brought up the fact that I think there's an inconsistency between the public and the private claims, and you have done, while I would suggest, and I suggested in private, that I think that they should be the same. I don't know why there's any difference, but the fact that you have been commensurate in reducing them so that at least there's some degree of consistency, because I believe there should be consistency, I appreciate that. And as I indicated a couple years ago when we were dealing with this, the witnesses and the sponsor had indicated that it's not about the money, it's about recognition and making sure that people are getting the attention that it deserves and the responses that it deserves. So I think that this is a responsible way of, perhaps a responsible way of dealing with it, even though it's still going to have impacts on both sides. It is a reasonable compromise, and I'm going to support it.
Delegate Six.
I definitely support this bill. I don't know that it's particularly perfect, but I don't think that we have the time to get it to that perfection. I would like for us as a body to explore this further, not just on the civil aspect, but we know, what this has brought to light, of course, is abuse in an institution, that by the state. And I really think that it's something that we need to explore further when it comes to like mandatory reporting, when it comes to, because this is what we were hearing from the victims. It's not just about money. And that's not what we should just be looking at. We should be looking at further aspects of the law. We can't do it between now and sine die, and I'm not suggesting that. But I think this is something that as a body that we need to really look at so that when we're talking about getting the counseling or we're talking about making sure it doesn't happen to anyone else, that's what I would like. That's what I would hope. Instead of putting together some knee-jerk, we see something, a more responsible look at how can we prevent it. Is that?
Delegate Grammer, then Eric Can, and then we're stopping.
So I just wanted to respond and maybe get to why I'm going to be no on the amendment. I think it has some good things. Taking out the forced adjudication, I think, is positive. But I wanted to kind of speak against the comments about ambulance chasers. I think those people, in most cases, inform those who have legitimate claims. And I think without those folks doing that outreach, legitimate victims wouldn't even know this process was happening. I don't think that's what these cases are about. And frankly, I agree with Delegate Cardin. I think these cases are very limited. I think they will work themselves out. I think that limiting the claim to one claim instead of the reality of the nature of the offense, that is a real problem for me in this amendment. And frankly, I don't. It's part of why I don't see the bill as being necessary in totality. So that's why I'll be a no on the amendment today.
Are we moving the bill in the next few minutes? Is that the plan?
Yes.
Okay, I'd like to use my hold.
I already announced yesterday that if people wanted to submit amendments, that we were going to be considering the bill today. So I'm not going to be entertaining a hold on this legislation this morning. We're on the amendment. Are there further comments regarding the amendment? Delegate Phillips.
Mr. Chair, I'm looking at the council fees, which is something that I brought up. The way this is written, my sense is it would only apply to state actions against the state. Wasn't it intended to be both the state and private?
It's only the Maryland tort claims?
So it only applies to Maryland tort claims, doesn't apply to private actions?
All right, it was the committee's intent for the fees to be 20 and 25% for all claims and not just the ones that were public or private. If we need to make a technical amendment in order to do that, we can do that, but we would need to adopt this amendment, and then we would need to take up that amendment next. So that was the committee's intent was to make sure that it was for all cases, not just for that one.
See, this is not in the local government tort claims act, does not have this.
No, I'm saying just for the purposes of these claims, to have it to be 25% and 20, just for the purposes of these.
In local government, state government.
Yes, all three. So what we're going to do is there is a motion on this amendment, so we would be making an amendment to the amendment here in a moment. We're going to make that change to make that clear. And with that, all in favor of the amendment that is before you, because then we'll make an amendment to this amendment. All in favor of the amendment, would you please raise your hands? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. There are 14. All those opposed to the amendment? 1, 2, 3, 4, 5, 6, 7, 8. The amendment is adopted. Now, this is going to be an oral amendment, but just to be clear, the intent and what we will have drafted is to ensure that all cases see attorney's fees at 20% if they are settled and 25% if they go to judgment, which means that they went to court. And so for this universe of people, for the people whose claims were barred in the past. So could I have a motion on that amendment?
Second.
Motion and a second, and we'll take discussion. Delegate Cardin.
I just want to just make sure that Lauren understands that it shouldn't be for all abuse, but only for the abuse in the realm that we're talking about.
Only the abuse in the realm that we're talking about, not something that happened today.
Is there a way to identify just this
Like, what if
group?
the cases are already, there's already been an attorney retained? Are we talking prospective?
We can't address the issues related to contracts that have already been formed. So it would be as of the effective date of the bill.
So yeah, from
It would be
June,
as of the effective date of the bill. Yes, so it would be as of anything that people enter into on June the 1st, 2025.
and but not prospective for people not included in this universe of
Correct,
people.
only in this specific universe.
Thank you.
Whether it is a public case, a private case, or a local case. Is there further discussion? Delegate Grammer.
This is on the bill, right?
We're on
I'm sorry.
my oral amendment on, okay. On the oral amendment on fees, all in favor, raise your hands. All in favor, raise your hands on the oral amendment on fees to 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Anyone opposed? Seeing none, the amendment is adopted. We now are on the bill as amended. Delegate Grammer. There's a motion for a favorable and a second as amended. Delegate Grammer.
Thank you, Mr. Chair. And finally, on the bill, I just wanted to say, I was talking with Delegate Moon here about this. This is a very limited scope of claimants. It's 4,500 now. That appears to be the at least claimed totality of the claimants. That is very small. It's not even close to what it was in asbestos. And these cases are not going to be I want to get back to the fact that when we discussed this issue, we talked about the church and the church's infractions. And even though people mentioned that the state was going to be liable to a degree, I think what we're doing here is a bit of a knee-jerk reaction to numbers that I think, frankly, aren't accurate at all. I think the scope is very limited. These cases will be worked out over a matter of years. So I don't think the state is, the claims about how much the state is going to be on the hook, frankly, I think are dramatically overblown. So I think we're not being super honest about how much the state is going to be paying for these. I think the appropriate step here is probably to actually study this for a year, take what the claims, the current claims, how much they're paying out, and extrapolate that forward to see what the total claims are going to be. I think a lot of people are including information that's coming from the AG's office, or the numbers are much closer to 1,500 to 2,000. Most of these will be settled, most of them for much less. So I think we're really doing a disservice. There's a lot of talk about people that have been harmed by the government this year, this session, and this body. And I think we're really doing a disservice to people that have really suffered some of the most egregious infractions that any person has ever suffered under the care of the state of Maryland. So I think we're really doing the wrong thing here today, and I think that's why I'm going to be a no.
Delegate Arikan.
Thank you, Mr. Chair. I am so shocked. This is the worst bill I think I've ever seen in the 7 years I've been down here. The idea that some children's rapes are less valuable than others based on who the rapist was is so beyond disgusting to me. I am almost at a loss for words, which I'm sure many of you are shocked by.
I was just doing the math, taking all of this in, and it's, from what I understand, we're talking about a universe of at least 4,500 cases. And, you know, considering the $400,000 minimum, that equals about $1.9 billion at least. I mean, considering the budget deficit that we're dealing with, you know, I mean, we have a budget crisis right now in the state of Maryland, and we're talking about adding an additional $1.9 billion. What is that? Yes. Okay, now correct me. I mean, I'm asking questions because I'd rather us have a discussion before I make a vote on it. So, yeah, correct me if I'm wrong.
Thank you, Mr. Chair. You're absolutely incorrect. That is the painful thing that the bill sponsor is trying to do, is to, because we do have a budget crisis, is to limit, without limiting the pain. And I don't want to go back and forth because I know the floor is calling us with folks on the committee, but I wanted to clarify something that I'm happy, what I did not say in my initial comments was that I'm happy to see, we're not happy, but I do appreciate or can recognize that there are a limit on attorney fees, because sometimes you do have individuals, you know, with various cases that constantly, like, you know, prey on people, prey on people's pain. And so I can, you know, understand, as you know, based off the conversation we had during the hearing, why you do limit those attorney fees to 20 and 25% that they can receive, because it is about the victims and people. Even though, legislating is easy, and it can be hard and difficult when you are personally experiencing something. So, you know, I had to do a biomarker bill while my mother was going through cancer. So the way that the bill sponsor was attacked regarding him going through having, you know, being a victim, I think it was just inappropriate, because legislating is not easy and people have to bring stuff even when they're in pain. And so I wanted to clarify and make it clear that that does happen. There are ambulance chasers, and unfortunately we do have a budget crisis, which is why he unfortunately had to bring this bill forward. And as Delegate Simpson, I would say this in closing, it is my hope that in the midst of this, that people can get the healing and the treatment they need. So with that, I'm not gonna go back and forth, but I wanted to clarify that. What Delegate Grammer mentioned and clarify, Delegate Congolo, that is why he's trying to bring the bill forward, is to limit the deficit, but not limiting the pain and erasing what people going through. With that, I'm done. I'm not going to say anything else. Thank you, Mr. Chair, for the indulgence.
Look, I think that I know that there are trial lawyers across the state who fight for their clients, and they fight hard for their clients, and there is nothing about that that should be in any way impugned. And it's not going to be impugned anywhere in this community and anywhere in this legislation. I think that the issue here is we need to begin to figure out the size and the number of these complaints. We're setting a one line in the sand that says here are the claims that have come in. We can begin to plan for those. Going forward, we make it clear what would be available for those future people. We don't go retrospectively. That's what we're doing here, and so that's the purpose of the bill and why we're doing this today. Very quickly, Delegate Congolo, are you done or are you?
No, I'm not done.
Okay, go ahead very quickly and then.
So just really quickly, I understand that there has been a cap or there's been a limit on, how much can be paid out and what the percentage that the attorneys are going to be compensated. However, this is still a liability. We're still talking about 4,500 people times $400,000 at a minimum, which equals almost $2 billion. So that argument really, that doesn't make a strong case for the fact that we still have to pay this out. Who's going to pay this? Taxpayers.
My understanding, yes, that's precisely right.
It is right.
But first, my understanding is that there are 1,500 cases that have been brought so far of those 4,500 that have been identified. My presumption is that those 4,500 are going to be in the courthouse door. So those would still receive the caps that are under the current law of 1.5 million and 890,000. So nothing about what we do here today, unless they file after June 1st, nothing about what we do today impacts those people.
Okay, so that's the 1,500 that you're talking about. Okay.
1,500 definitely. There's, I believe, a case in Howard County that's about ready to go in front of a judge and go through begin that process here in the next couple of weeks. Delegate Grammer.
Thank you, Mr. Chair. And I just wanted to speak to Delegate Congolo's point, because this is the entire crux of the issue. So the number you mentioned, 1.9 billion, the media is here today. As we go forward, they'll be able to assess whether that was accurate or not. And my broader point is that the number we've been given in advocacy of this bill is like 15 billion. Like, we're going to be paying $15 billion out to survivors. We can't afford that. It's going to break the back of the state. And I don't think this is accurate in any way, shape, or form. So I haven't seen any data based on the claims that we're currently going through. I think the information or the kind of advocacy that we're hearing, these astronomical numbers, are false. I don't think it's going to break the back of the state. Yes, there will be a payout, but these people are owed something. We're told it's not about the money, but we passed a bill about civil liability, which is about money. So I think we should be taking a pause here to say, like, look, these numbers are overblown. We were in support of the victims that went through this. We should continue to do that and not shrink the liability when it's found that the state is on the hook for more than we anticipated.
Mr. Chair, I move the previous question.
There's a motion for the previous question. Is there any objection to moving the previous question? Seeing none. All right, that's fine. All in favor of moving the previous question? Again, it's a motion to move the previous question. Please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Anybody opposed to moving the previous question? 1, starting over here. 1, 2, 3, 4, 5. We've moved the previous question. We're on the bill as amended. We've heard debate. We've had conversations. The Vice Chair,
Yes, and if I could explain my vote.
Yes.
This is not easy. This is not meant to leave anyone out. There was a lot of work put into this, and this, if we need to, the law is always evolving. I will always say that. The law is always evolving. That's all.
Valentine? No. No. Crutchfield? Yes. Yes. Cardin?
Yes.
Yes. Tomlinson? No. Pasteur? Yes. Tolles? Yes. Simmons?
Yes.
Yes. Boucher? No. Phillips? Yes.
We're fiduciaries. Consider ourselves trustees. We've made a lot of decisions over the course of this term about how people's monies are being spent, how we're going to raise revenues, and it's been very challenging. I sat here for 2 years listening to Chair Wilson bare his soul. But I also sat here this year and I heard him bare his soul again. This will provide some level of certainty, I believe, and it will still allow people to have their day in court. And I think it will position the state to resolve these matters in a more expeditious way. As an attorney, that's what I see this really being about. Thank you, Mr. Chair.
Okay. Phillips, yes. Stinnett?
Yes, with that explanation.
Go ahead.
I hear on both sides, well, thank you, Mr. Chair, I'm sorry. Here on both sides, it's very challenging, especially at the time that, I came in to kind of really get briefed up and kind of have a full understanding. But overall, I'm hoping that at the long run that we're making the best decision as possible.
Thank you. Delegate Congolo? No, go ahead.
Okay. I think that we definitely don't want to minimize and deny the pain and suffering of people. But I also look at the pain and suffering of our financial state here in Maryland. And as a business owner, as someone who is very much, versed in budgeting, we have to be realistic here and what we can do, what we can afford. And we've gotten to a place where we don't know how to manage the funds that we have. And I hope that if this does make it over to the Senate, that they see reason, because this is not it. So my vote is no.
Delegate Erican is not present. Taylor? Yes. Simpson? Yes.
I just want to make sure to make it clear that I do know that many of us on this body, I have confidence that we are going to address this problem. I mean, I'm looking at so many of us who are victim advocates or ourselves have been survivors. And therefore, I know that this body is committed to supporting the individuals who have been through this. And I really am thankful that I serve on this group. And I know we're going to make a difference. I know it's not the most perfect solution, but it is, I think, a good balance for now between trying to make sure we support the victims as well as protecting our state, not the individuals who've harmed people, but the responsibility that we all signed up to do. Thank you.
Grammer?
Explain my vote, please.
Yes.
Yeah, thank you. So the governor's slogan is leave nobody behind, and I think today we're leaving victims behind. We were told the solution to this problem was to pass the legislation that gave these folks a civil liability. Now, when we're surprised by the liability of the state, we're told it's to minimize the liability, and it's not about the money. I don't think we're fiduciaries. I think we're representatives, and I think regardless of your district or the area you represent, I don't think 90% of voters think the state should limit its liability when it comes to predators and pedophiles. So I think in this bill, we're minimizing the accountability of the state in defiance of what the people would want. and that's why I'll be a no today.
No. Sample Hughes.
Thank you, Mr. Chair. Again, as I said earlier, this is one I've been grappling with, and I know as everyone on this committee has. And first and foremost, I just want to say, and this is to explain my vote, want to say thank you to the bill sponsor because he left his heart on that table, and I really am grateful for his ability to even talk about this subject. But what I do have concern with is that, you know, we as a state, these people who have testified and said what has happened to them under state supervision, we as a state have promised that they were going to be safe then. And I feel like, you know, we're not providing the safety net that they need now. And yes, it's heard, it's not about the money. But not only are they saying how it has impacted themselves, but that one gentleman stated he won't even let his children go with anybody because he don't trust anybody. So his children very well may need therapy, and his grandchildren. And so I don't know, I just feel like we as a state is always, you know, saying this is going to bankrupt us, this is going to bankrupt us, just like we did with that prescription plan where people were harmed in 2011 and they thought they had prescriptions now, and they're now talking and saying how they can't get that service that they need. And I feel like that's what we're doing again and again and again. And yes, I know about fiduciary responsibility. I've been in politics for now 18 years. But so this one to me, it just really hurts me. I feel like we're hurting these people all over again, and it's not equitable. So that's my reason for my vote. And thank you, Mr. Chair.
You need to cast your vote. Your vote is no. Sample Hughes, no. Moon.
Explain my vote, Mr. Chair.
You need, I should have said this before. Please cast your vote first and then.
Yes.
Delegate Moon.
I'm a yes. And Mr. Chair, I just want to, again, lift up Chair Wilson's courage in sponsoring this bill. I think those of us who are yes, and I've talked to almost everyone here, none of us wants to be a yes on a bill like this. I was one of the longtime proponents of opening the door to a civil remedy that actually previously did not exist. And I think we have to remember that. We created the right for these folks to have their day in court after years and years of struggle and refinement and appeals, and we got it. And I wish we had listened potentially to some of the wisdom of some of the colleagues that flagged questions about potential state liability. And I have to apologize both to the survivors and to our body that we did not do that. And here we are today. But unfortunately, as you see, some in the minority party think we should repeal and close the courthouse doors to save us from any additional exposure. And others in the minority party think we should stay exactly the same. And so here we are, I think, striking a balance. And as to the question about the public versus private institutions, we are constitutionally required to maintain a balanced budget and do not have the option of bankruptcy to run from our obligations the way our private counterparts do. And so there is a very different legal exposure that we face as fiduciaries. So with great regret, I am a yes, and with apologies to the victims.
Yes. Conaway? Yes. Yes. Kaufman?
Yes, to briefly explain my vote, this is the toughest vote I've ever cast. I don't like it, but in the name of fiscal responsibility, I'm a yes.
Williams?
She needs a moment.
Yes. I'm so sorry, Mr. Chair.
It's okay.
I agree with the comments my colleague from Prince George's County made earlier, that this is tough. You can't quantify someone's pain, and we're trying to do that today. And I do hope that they get the services that they need and they deserve. And prayerfully, when the courts adopt the rules about how this will work, that will happen. So with that, I'm a yes, because I know we have to do something. And it's not about the money, but it's about moving forward for these individuals
and that they will hopefully one day find peace. So thank you, Mr. Chair.
Thank you very much. The motion for a favorable was adopted on House Bill 1378. That concludes the voting session for this morning. We will now go to the floor. We will come back and address remaining bills on voting list 17 after the first session of the House delegates today. Thank you very much.